Well, my thanks to the Council of State Governments for the invitation to join you and to discuss a topic which I describe as State Attorney General activism. At its essence, the issue is whether the state AGs are invading the province of our state legislators. But before I get into the essence of it, I also want to thank my host, Attorney General Stingeon. You know, well, you folks drove a bus to Fort Lincoln last night. General Stingeon delivered us by boat. And of course, it was a beautiful night. We had a wonderful trip down and a wonderful trip back. And thank you, Wayne, for your hospitality. Folks, this topic is one that I believe is worthy of much broader public discussion than that which has previously been provided by the Wall Street Journal editorial page or by policy papers issued by free enterprise think tanks. And hopefully my remarks today will foster some additional thought about the role of the State Attorney General as a law enforcer versus a public policy maker. When I was sworn in as Attorney General of Colorado in January of 2005, I understood my role would be significantly different than the work that I'd done as an elected district attorney in Colorado Springs or as United States Attorney for the District of Colorado. Those public law offices did virtually nothing but litigation. The district attorney's office prosecuted criminal cases and had limited civil jurisdiction in consumer protection and public health areas. As U.S. Attorney, my office did all the criminal and civil litigation for the United States in the District of Colorado. As Attorney General, I understood I would be the legal advisor to all departments, agencies, and boards and commissions in Colorado state government. My office would issue hundreds of legal opinions, both formal and informal, on a wide variety of subjects pertinent to the operation of the state of Colorado. I also understood I would be involved in a broad range of civil litigation on behalf of the state, both as a plaintiff and defendant, in addition to the criminal prosecution responsibilities that I had. But as to my role as the protector of the broad public interest, primarily in regard to Colorado civil and criminal statutes relating to consumer protection and environmental protection, I still saw myself as assuming the familiar role of law enforcer. In fact, I would be the chief law enforcement officer in Colorado. I was the state's top cop. Isn't that what you tell everybody? It would be my job to enforce criminal and civil laws passed by the state legislature to protect consumers from fraud and deception. It would also be my job to enforce a variety of statutes enacted to protect the public from air and water pollution and other health hazards. And I don't believe I was naive. I was well aware that state attorney generals had been involved in some somewhat controversial litigation, including the massive civil suit against tobacco companies that had culminated in a settlement agreement in 1999 involving as much as $240 billion, with a B, and that many free market conservatives questioned whether that was a proper exercise of the state police power. I knew that several attorneys general, like Elliott Spitzer in New York, had made quite a name for themselves taking on corporate America, and that many on Wall Street and elsewhere thought they were overreaching. No, I wasn't naive, but neither was I fully prepared for what I found when I joined the ranks of the state attorneys general. In March of 2005, after I'd been the AG for 2 months, I attended my first meeting of the National Association of Attorneys General in Washington, D.C., affectionately known, by the way, as NAG. In the weeks prior to that meeting, I was flooded with invitations to go to elegant private dinners or receptions hosted by large law firms or various corporate entities while I was in Washington. That's not something that occurred when I went to district attorney or U.S. attorney meetings. I was also invited to a meeting of the Republican Attorneys General Association, RAGA, which would take place the day before the NAG meeting. At the RAGA meeting, I met with other Republican attorneys general. Republicans held the job in 21 of the 50 states at the time. I'd done a little research and learned that in 1998, there was as few as 14 Republicans. And out of concern for the alarming underrepresentation of Republicans, a few attorneys general and the Republican National Committee had founded RAGA. It was funded by individual and corporate contributors, many of whom were concerned about the growing activism among attorneys general that they believed was undermining free enterprise. And RAGA had had considerable success in the first couple of election cycles, and it was contributing significant funds to help elect Republican attorneys general. That led, not surprisingly, to the creation of DAGA, a Democrat counterpart, similarly dedicated to electing Democrat attorneys general. As time passed, many companies and interest groups contributed to both RAGA and DAGA. At a reception at my first RAGA meeting, I met dozens of representatives of various corporations and trade groups, and I recall being a bit perplexed. What was the propriety and the necessity of such an effort to influence attorneys general? Isn't it inappropriate to attempt to influence law enforcers as opposed to lawmakers? When I came into the room for my first NAG meeting, the scene looked very much like I had experienced at National District Attorneys Association meetings and at meetings where all the U.S. attorneys got together. Tables were assembled to create a rectangle, and a name card and a Colorado state flag marked the place where I was to sit. But when the NAG president called the meeting to order, I noticed that in addition to the attorneys general sitting around the table, there were more than 150 people sitting at tables in the rear of the room. And I whispered to a colleague sitting adjacent to me, "Who are all the people in the back?" I asked. He glanced at me in a way to suggest that that was a pretty dumb question, and he smiled at me and said, "They're here to lobby you." And indeed they were. I have found that the attorneys general are subject to intense lobbying in much the same fashion as legislators. But instead of seeking your vote, the lobbyists are hoping that you will or will not sign on to an amicus curiae brief in the federal appellate courts, or more importantly, that they can convince you to refrain from initiating or joining a lawsuit against their company or their interests. In rare instances, an attorney general will be encouraged to join a litigation that is regarded as helping the lobbyist company or industry. Or the new lobbying effort is by plaintiffs' firms throughout the country to convince an attorney general to bring a suit and hire them to bring it on a contingency fee basis. The lobbyists spend a great deal of time educating attorneys general about various issues that may become fodder for litigation in the future. And corporate America is now investing millions of dollars in attorney general races in the various states in an attempt to protect their interests. Well, how did it come to this? 15 years ago, no one cared much about state attorney general races. There was no RAGA or DAGA. NAG meetings were quiet affairs, largely free from outside pressures. A few of my attorney general colleagues who have held office for a long time and lived through the transition may have a better perspective than mine. But from what I've been able to ascertain and personally observe, the current situation is a confluence of interrelated trends. The bottom line is that attorney generals have become more litigious, more high profile, and more politically ambitious. Precisely in which order these occurred or which trend led to the others, I'm not completely certain. But it's clear that corporations and other interest groups have figured out that the state AGs can do lots of damage to them. And they contend many AGs are aggressively pursuing litigation based on novel legal theories rather than legislatively created remedies. Many of the critics have come to call this phenomenon attorney general activism. Well, what exactly is attorney general activism? Is it capable of definition, or is it simply a case of you know it when you see it? Well, let me give you three I knew it when I saw it examples and then try to define it. In the aftermath of Hurricane Katrina in 2005, gas prices rose sharply. The public was angry, perceiving that the rise in price was more the result of corporate opportunism than market forces. The state AGs, always wanting to be perceived as diligent problem solvers, weighed in with their concerns. The FTC and several state AGs initiated investigations. In fact, my office has had a half a dozen gas pricing investigations the last 10 years. I distinctly remember a nationwide phone conference in which the FTC gave the AGs a preview of a report they were issuing the next day. Essentially, the FTC, as well as the state AG investigations, found no systemic wrongdoing. They concluded that the rise in prices was attributable to market forces, including the highly volatile spot and futures market. Various AG investigations reached similar conclusions. So I thought that would be the end of the matter and expected the phone call to wrap up very quickly. But a veteran attorney general from the Midwest, not Wayne, interjected and made what I considered an amazing assertion. In fact, I had to write it down. He said, quote, "Just because we haven't found anything illegal doesn't make it right and doesn't mean we should do anything about it," unquote. We, quote again, "We need to do something about these obscene profits," unquote. Folks, in my opinion, that's the mindset of an activist AG. Luckily, market forces shifted a short time later, and the Attorney General's interest in the issue declined at the same rate as gas prices. But needless to say, the pressure's back on when it comes to gas prices. In 2006, shortly before he left office, California Attorney General Bill Lockyer filed suit against the world's 6th largest car manufacturers. In the suit, California sought to recover damages for all environmental damage caused by automobiles since their invention. It was California's contention that cars are a public nuisance the manufacturers have inflicted upon it. The suit ignored the fact that the California legislature long ago passed the nation's strictest auto emission standards, and that the companies had specially manufactured a significant portion of their fleet in order to comply with those standards. The suit also didn't deal with the reality that California constructed an enormous highway system to accommodate this alleged public nuisance. When this suit was dismissed by the federal district court, which found it a political issue inappropriate for courts to decide, the California AG's office issued a statement that said in part, and I quote, "If there's a problem, there has to be a legal remedy," unquote. I personally believe this is once again a case of AG activism. Now, the New York Attorney General, Andrew Cuomo, like his predecessor, Eliot Spitzer, and several other Eastern AGs, do not like coal-fired power plants. They brought suit against 5 major utility companies who provide coal power energy, none of which are located in their state. The purpose of the suit is to force them to reduce carbon emissions. The court also dismissed this case as involving a non-justiciable political controversy. But not content to fight power plants in the Northeast, the New York AG, Andrew Cuomo, has taken creative legal steps under New York securities law to block coal-fired fuel plants in Kansas and Colorado. Folks, I believe it violates the fundamental precepts of federalism to suggest that one state can have such control over the business of other states. In my opinion, state AGs interested in weighing in against global warming should enforce the laws of their own states and encourage Congress to pass air quality laws sufficient to reduce greenhouse emissions throughout the country. So my definition of AG activism is this. It's when an attorney general attempts to remedy a real or perceived problem through means other than that intended by a legislative body. My test in determining whether to exercise state power to sue someone is simply this. Has a law of the state of Colorado been violated, and is there sufficient evidence to prove it in court? I won't bring, and a lot of my fellow AGs won't bring, a legal action to stop any conduct, regardless of their personal view of it, if the legislature has not provided us a means to do so, either by express statutory authorization or by statutory recognition that we retain certain common law powers. And there's several situations in Colorado where the legislature is recognized that I do retain powers that AGs had at common law historically. The aggressive litigation posture taken by some of my fellow state attorney generals has led critics to question whether they're engaged in a violation of the separation of powers. By using perceived common law powers to achieve public policy objectives they deem desirable, they are in essence legislating and regulating by litigation. They're shaping public policy, traditionally the legislative function. But the consent decrees by which they resolve the litigation and secure public policy changes are not subject to either legislative or executive approval. Now, Do I lobby the legislature to provide me greater statutory enforcement authority when I believe it's appropriate? You bet I do. We all do that. That's clearly part of the job. Do I join multi-state actions where several AGs sue a wrongdoer? You bet I do, if I believe the defendant has violated Colorado law. For example, we've recently caught pharmaceutical companies whose patents on certain products were about to expire, paying off potential generic competitors to stay out of the market. That's a violation of the antitrust laws of Colorado, and a multi-state action is a very efficient and effective means to resolve it. In fact, what we AGs find is that many of the companies that we're pursuing prefer a multi-state format for these cases because it gives them the ability to resolve it throughout the country. So culpable corporate defendants often view multi-state actions as the preferred method. But there have been several multi-state actions where the best and most creative legal minds in my office could not conjure up a viable legal theory under Colorado law to support our participation. Those cases sometimes go forward because the absence of a credible legal theory has, amazingly enough, thus far not been a barrier to proceeding for state AGs who tend to bring such cases. Why is that? Well, despite the two instances that I told you where courts threw cases out as involving non-justiciable political controversies, the fact is that a lot of these cases settle. Why are they typically successful? I believe it's because when threatened by a suit by multiple AGs, most publicly held companies ultimately conclude that they can't afford to fight. And I don't mean they can't financially afford to fight. They make lots of money and they can afford great lawyers. But they also have a fiduciary obligation to their shareholders. And experience shows that bad headlines generated by a suit by multiple state AGs will likely do more damage to a company's market capitalization, in other words, their stock price, than any verdict 5 or 10 or even 15 years down the road. So there's a great temptation to settle if the price isn't too high. The companies know it, and the AGs know it, and the suits typically settle. And for many of the AGs, such activism has become very good politics, as they've taken on the mantle of the corporate dragon slayer and have frequently parlayed that into higher office. I believe the only effective remedy for AG activism is action by the state legislatures to statutorily curb it to the extent that they're able, if in fact they want to. It's obviously up to the state legislatures to decide whether they want to. Legislators that are so inclined can restrict the nature and scope of AG consumer protection powers and prevent AGs from delegating the exercise of state police powers to private attorneys. It's clear that states can limit the powers given to the Attorney General under state consumer protection laws because many states have done exactly that. The fact is that some state consumer protection laws are dramatically broader in scope than others. The more conservative state consumer protection acts, and I include Colorado among them, are based on the Uniform Deceptive Trade Practices Act, as opposed to a so-called baby FTC Act adopted by a number of other states. The ones based on the Uniform Act contain a laundry list of specifically defined deceptive trade practices, while state laws modeled on the FTC Act prohibit what are described as unfair or unconscionable practices. In my opinion, if you look at the history of these cases, such broad and open-ended provisions are an invitation to AG activism. Most of the specifically defined deceptive trade practices prescribed in the Uniform Act states require the violation be either knowing or intentional. In many FTC acts, no knowledge or intent is required, essentially a strict liability statute. In Colorado and other states with a more conservative Consumer Protection Act, treble damages are limited to cases in which there's clear and convincing evidence of bad faith by the defendant and not available in class action. And finally, standing to bring a private Consumer Protection Act claim is limited in Colorado and many other states to those cases in which a plaintiff can establish a significant public impact from the alleged deceptive practice. In other words, it can't be purely a private dispute that's actionable. Now, some of the most significant examples of regulation or policy making through litigation have come about when attorneys general hired private law firms to pursue litigation on a contingency fee basis. In fact, of course, The tobacco case began as a contingency fee case in Mississippi. As a result, primarily, of the tobacco case and the genre of cases immediately after that, Colorado and other states have severely restricted the circumstances or the terms upon which AGs can hire outside lawyers on a contingency fee basis. I think a good argument can be made that the exercise of the state police power should only be exercised by a neutral public official who is not financially vested in the outcome, and that such neutrality is lost when cases are shot to contingency fee lawyers. So these are just a few examples of what, and by the way, one of the things we did in Colorado is some states prohibit the AG from taking a case out on a contingency fee basis except with the permission of the governor or the legislature. In Colorado, we did it another way. AG, you can do it, but the lawyers have to keep track of their hours, and at the end of the case, they can't make more than $1,000 an hour. Now, that seems like a lot of money, but keep in mind in the tobacco case, it was determined that some of the law firms made in excess of $15,000, $20,000 an hour or more. So these are just a few examples of what legislators may look at if they have concerns about the expansive powers exercised by state AGs. But in the meantime, in the aftermath of the tobacco litigation, there's no question that a cottage industry has sprung up. There are now hundreds of people making a very good living lobbying state AGs. In fact, all of our former AG friends now come to our meetings. They work for big law firms, and they lobby us and make a heck of a lot more money than we do. Coming from my background as a district attorney and a U.S. attorney, I still find all this lobbying disconcerting. But frankly, because of the aggressive litigation posture taken by many AGs, I've also come to understand it. Let me conclude with a short story that really sums up the situation we find ourselves in. The general counsel for a large beer company, I'd been the AG for about 6 months, and the general counsel for a large beer company came in to see me to tell me what they were doing about underage drinking. I was on a subcommittee of the AGs that's dealing with underage drinking issues. And one of the things we were discussing is recommending higher threshold guidelines in terms of the viewing audience where companies can advertise. They voluntarily agree right now, I think, beer companies not to advertise in any program where more than 30% of the audience is under 21, any type of program. And the AGs were discussing, maybe we should move to 85%, and that would limit them from advertising in certain sports programming that they love to do. So that's what their significant concern was, and they came in to see me, tell us what they were doing about underage drinking. The general counsel brought with her a lobbyist by the name of Michael Moore, not the crazy wacko leftist Michael Moore, but a Michael Moore who used to be the Attorney General of Mississippi, and in fact the guy who started the tobacco case when he hired a law school classmate by the name of Dickie Scruggs to take the case on a contingency fee basis. Dickie Scruggs made over $1 billion. And oh, by the way, those of you in the South may know that Dickie Scruggs just went to prison for trying to bribe a judge for $40,000, despite the fact he made $8 billion. So anyway, we had this meeting, and Michael Moore, the guy who'd started the tobacco case, is there to help lobby. Without any hesitation, said, "We don't want to be the next tobacco." And folks, I understood exactly what she was saying. That's where we're at. Thank you very much for your time and attention today. I hope I've given you a couple things to think about when you monitor some of the activities of your attorney generals in the years to come. Thanks.
Stay up here.
Okay.
Can I ask you a few questions?
Yeah, sure.
Attorney General Suthers has graciously agreed to answer questions. If you have any, feel free.
Yeah, everybody loves their AG.
It was so complete.
Anybody? You know, last time I saw, I think we're almost up now to about half the states have some limitations on contingency fees. The vast majority are having to get authorization. But I think 3 or 4 states, I can't name them, have some kind of, regardless of what's transpired, there's some sort of hourly limitation on it. And I obviously, you know, on occasion hire outside counsel in areas where we don't think we have enough expertise. But I've always made it a habit to go over the legislature and get the money appropriated, and they want an explanation as to why you need to hire outside counsel, and I found them fairly cooperative in the past. Yeah.
To some extent, I think mentioned this as a possible suggestion for this meeting about one of the questions to it. But isn't disclosure of the hiring of outside counsel, I know we dealt with it on the term of sending leadership here in North Dakota, but I'm under the impression that some states, a lot of this contingency attorney hiring is going on in those offices that no one really knows about.
Yeah, I definitely believe that, and I'm not sure I'd impose a strict bidding, you know, goes the lowest bidder type of thing. Obviously, that has issues. But I think you ought to have a process, a very open process by which firms apply and in which a decision is made and you're able to publicly defend that decision and everybody can find out what firm has been hired. I think that's very important. Because you're right, there's been a lot of issues. In fact, the most immediate little issue going on in Mississippi is over Dickie Scruggs having been hired by the AG's office.